please put your phones on silent mode.
Round final. Who's doing the timing? Tell them to stick to time. Yeah, we can start now.
Yes.
Right?
Yeah.
You start.
Yes, yes. What is seeking a petition to oppose the ayes?
Your Lordship, for the sake of convenience, the counsel for the petitioner would like to address the bench collectively as Your Lordship.
We suggest you refer to us as your ladyship.
Yes, indeed, Your Lordship. Much obliged, Your Ladyship. Your Ladyship, before proceeding, the counsel for the petitioner would like to serve Your Ladyship with a compendium. Your Ladyship, there are a set of 3 compendium on the side of the counsel for the petitioner. Your Ladyship, if you permit, the counsel for the petitioner would like to start with the facts of the case in a nutshell.
Yes, please.
Your Ladyship, the facts deal. Your Ladyship, the facts deal with the country of Dhenindya. In this country of Dhenindya, it is stated that it is an agrarian economy where more than 50% of the population is dependent on agriculture for its economy. Your Ladyship, the factual matrix further says that in this particular country of Dhenindya, there is industrial pollution of 35%, there is vehicular pollution of 18%, and other things including agricultural pollution of 18%, Your Ladyship. Your Ladyship, the dispute is between 2 states which belongs to the nation of Dhenindya. State A, State of Dehya, and State of Pundideep. Your Ladyship, State of Dehya and State of Pundideep, they share a border of 220 kilometers and they are the neighbors. Your Ladyship, State of Dehya, they passed a legislation in the year 2023, and previous to that, prior to that, the State of Dehya, they passed a notification in the official gazette prohibiting the practice of stubble burning. Your Ladyship, since this is an agrarian country, the practice of stubble burning has been mindlessly being followed. Hence, to curb this practice of stubble burning, the State of Dehya passes a state legislature banning the entire practice of stubble burning. Your Ladyship, now the first issue talks about the maintainability of 4 cases. The first one is the original suit which is being filed by the State of Dehya against the State of Pundideep for the deterioration of the health conditions of the residents of both the State of Dehya as well as Pundideep. The second case, it is a writ petition filed by the Dehyan Youth Climate Association against the State of Pundideep. Your Ladyship, This case again revolves around the grounds of deterioration of the health conditions of the people. Now there is a third case, which is a writ petition, which is filed by the Kunditi Agricultural Society against the state of Devi. This particular writ petition, it is challenging the grounds of arrest made by the state of Devi according to the law of their land. Now the fourth case, it is a case contested by the National Standards Broadcasting Authority against the state of Devi. Your Ladyship, now there are 4 news channels which are operated and controlled by the state of Devi in their state. So these particular news channels, they telecast few content. These content, they call state of Kunditi to be backward in science and unaware of the climatic conditions. So hence challenging these remarks which is being telecasted in the satellite TV, there is a writ petition which is being filed, Your Ladyship. Your Ladyship, this is the facts in a nutshell. If Your Ladyship might permit, may I please move on with the issues in hand.
No, but how did the matter reach here? All of them were clubbed?
One of the issue one, it talks about clubbing and hearing it together also, Your Ladyship. As I am the speaker number 1, he would be addressing the issue 1 and issue 4, and my co-counsel over here, he would be addressing issue 2 and 3. Since Your Ladyship asked the question about clubbing together and tagging along, I will be addressing it, Your Ladyship, in the fourth comment. Your Ladyship, do I begin with the...
I have a question.
Yes, Your Ladyship.
You are for the petition in which manner?
Yes, I'm the plaintiff in the first case, that is the original suit 35 of 2023, and in the second case, I will be representing the Devi Youth Association, Devi Agricultural Society, and in the fourth case, I'll be representing the National Standard. So if you permit, may I please proceed with issue number 1, Your Ladyship. Your Ladyship, the first issue, it talks about the maintainability of the of all the 4 cases. Starting off with the maintainability of the original suit. Your Ladyship, the original suit is filed invoking the original jurisdiction of this Honorable High Court under Article 131 of the Constitution of India. Article 131 of the Constitution of India elucidates about the original jurisdiction, where it says that a state can file suit against another state, against the sentence, against the union, or between 2 states. Invoking the same jurisdiction, it is humbly submitted that it is under 131 article that we have approached this Honorable Court seeking relief. Your Ladyship, apart from that, there is an evolved jurisprudence of parens patriae, which means that the government is the parent of the nation. Your Ladyship, in this particular dispute, it revolves around the deteriorated health conditions of the people. If you may peruse through the Moot proposition, Your Ladyship, it is more than evident that according to the study conducted, there are 12 years of lifespan which gets reduced because of this air pollution. Apart from that, Your Ladyship, the Moot proposition is also clear on the point that the young persons of this country of India, they are subjected to various lung ailments.
What is the basis of this statistic that has come up with?
Your Ladyship, this particular statistical report was given by a world-renowned university, and it is given in the Moot proposition. If I may, it is.
Just take it through.
Yes, Your Ladyship. It is given in page number 15 of the Moot proposition under paragraph 2. If you may peruse paragraph 2 of page 15 in the Moot proposition, the last 3 lines states, a recent study by a world-renowned university suggested that the residents of Devi and certain parts of Kunditi were expected to lose almost 12 years of life expectancy.
So is the report by any university binding on us? What weightage can be given to it in an evidence?
Your Ladyship, to answer that question, it of course falls under the category of secondary evidence under the Indian Evidence Act. But to answer the question whether it is binding or not, of course it is not. But for the sake of persuasion, of course, for the sake of elaboration, the counsel for the petitioner deems it fit that it may be produced before your honorable court, Your Ladyship, for your perusal, because the situation is that bad, and such universities, such commissions, such associations have taken the initiative to make report, do the primary data analysis, secondary data analysis, and find the report, and hence such report has been given. Your Ladyship, to further
I just have one more question.
Yes,
Do we
Your
have
Ladyship.
this report in the compendium?
No, Ladyship, it's
You
not in the
can't place
complaint.
it on record.
No, Ladyship, we have not been given from the authorities this particular report as an annexure. It is just being given to us.
Factual bit.
Factual bit.
Okay, just another question.
Yes, Your Ladyship.
At numerical page 5 of your memorial, you have mentioned that you're also coming to this court under Article 32.
Yes, Your
Whereas you just mentioned Article 131.
Yes, Your Ladyship.
Are you saying that you're not approaching us in 32 or you forgot about it?
No, Ladyship, I was dealing with the maintainability of OS right now. I was going to proceed with the maintainability of the other 3 cases.
No, what I'm thinking is, because jurisdiction issue has to be addressed first. So you are saying your co-counsel will be addressing the Article 32
No,
issue?
no.
Because in your memorial you have done, that's why I'm asking.
Yes, indeed,
In
indeed.
your statement of jurisdiction that we are approaching the court under Article 131 and 32.
Indeed, Your Lordship. It is just that the Council of Petition only submits that. I proceeded with the sub-issue 1.1, which deals only the maintainability of OS. I am proceeding with 1.2, 1.3, 1.4 as given in my pleadings, the memorial, which deals with the maintainability of the other 3 writ petitions. As well as I'll be dealing with whether it can be clubbed together or not.
What is the objection in this, in a nutshell, what is the objection of the maintainability? Is there an objection, official objection?
Yes, the objection that is raised by my learned friend is that, Your Ladyship, that exhaustion of remedies are not, after perusing their memorial, after perusing their pleading, I could figure out that the objection raised by them is exhaustion of remedies per se has not been resorted to. We have directly come to this Honorable High Court. So that is the contention that they are raising here. Your Ladyship.
So alternate remedies available over this.
Yes, Your Ladyship, that is what they are contending. Your Ladyship, if I may proceed. Your Ladyship, for your perusal, I would like to submit to this Honorable Court an article of the Hindu newspaper, which was published this very same Monday. This is the Hindu article, Your Ladyship, the second page of it. The second page of it, the last paragraph. The air quality deteriorates in Delhi in winter, mainly due to stubble burning in neighboring Punjab and Haryana. I want to place my reliance on this, Your Ladyship.
What is this document? It's an article.
It's an article which was published in the Hindu.
No, written by whom?
It's a news article.
Yes, Your
It can be by any news reporter. Again, I think my learned brother will have a question on the binding nature of such article.
You are just getting us reports and university.
Yes, Your Ladyship. I get it. I humbly submit that I'm not proceeding with the fact that it is binding on this Honorable Court. It won't be binding, but it is just for the sake of persuasion and to elucidate and elaborate to you that the current situation is very bad. Because the factual matrix is also very clear that people are losing their 12 years of lifespan. Apart from this, Your Ladyship, I would like to produce to this Honorable Court the EPCA report.
What is the air quality at the moment? Do you have any statistics for that?
Your Ladyship, according to this factual matrix, the air quality is not being given. I would refrain from quoting the air quality of India to India because the factual matrix is silent about that. Your Ladyship,
This report is presenting.
yes, thank you, sir. Your Ladyship, this particular report in 2020, this very same court in the judgment of Aditya Dubey Minor versus Union of India, it directed the EPCA, Environmental Pollution Prevention and Control Authority, to submit a report on the entire thing of stubble burning. If Your Ladyship would see the very first paragraph of this EPCA report, the very first paragraph in the first page of this EPCA report, it again states, every winter, the large-scale burning of crop residues from paddy crop in October and November, exactly this time span, in the neighboring states of Punjab, Haryana and Western Uttar Pradesh contributes significantly to the region's air pollution challenge. Further, on 28/2/2020, the Honorable Supreme Court directed the union and state governments take strong measures to ensure that stubble burning is stopped, as it has serious adverse health impacts on local communities and on the people living in the region. Your Ladyship, it is humbly submitted that it was this Honorable Court, which directed on the year 2020 to take strong measures. Your Ladyship, it is humbly submitted that the state of Delhi, that is we took a strong measure by enacting a legislature. Your ladyship, you will be aware of the fact that agriculture is a state subject. According to list 2, entry 6, agriculture, public health, sanitation, these are all state lists. It is for the state to deliberate upon and come up with a legislature. And as such, being aware of the constitutional provisions as well as this honorable court in the year 2020 had directed to take strong measures, and hence we had come up with this act. Your ladyship, it was priorly in 2016 itself with the directives given by this honorable court as well as the NGT. Your ladyship, we had come up with a notification that we had published in the official gazette. Further, after 2020, we had to abide by this honorable court, and we had come up with the act.
Council,
Yes, your ladyship.
you just mentioned about NGT.
Yes, your ladyship.
Don't you think all civil matters pertaining to environment, this is a matter pertaining to environment issue, should be before NGT only?
Indeed, your ladyship. But the contradiction over here is that we are filing the original suit against the state of Pundivi for appropriate relief that this honorable court deems fit, because the residents of both the states' health have been deteriorated. Your ladyship, you might be aware, original suit, either the relief can be sorted in the terms of damages, permanent injunction, or specific performance. The council doesn't want to reach to specific performance because there is no underlying agreement between both the states. But there is damages and permanent injunction. The practice of stubble burning is being mindlessly carried out by the learned French state of Italy. And over here, I'm humbly content submitting that by filing this original suit, that this honorable court might please direct the learned other side council, the state of Pundivi, to come up with any particular effective mechanism to curb the practice of stubble burning.
No, but as my learned brother is pointing out, effective mechanism can't be passed by Supreme Court. In a suit jurisdiction. So I think we can only give you an injunction or mandatory injunction in the nature, but the problem also is that mandatory injunction will be given to a party which is doing something. Is your allegation that the state is doing it deliberately to harm you, or is it that stubble burning, which you also said is a very old practice, is causing it? So is it not NGT which is more equipped properly to deal with this issue, is what my brother is pointing out, and I think that's a pertinent question the respondents are also pointing out to. Why this jurisdiction? And also one more question, and you clarify us, why 131, and what is the reason only original suit can be filed by a state against a state before Supreme Court? So elaborate on that also.
To elaborate on that, the honorable court time and again it had given directives in the year 2020, before that in the year 2014, and even there is a central policy. Your ladyship, as I mentioned, that agriculture is a state subject, and according to that only states can deliberate. The central government did not pass an act prohibiting stubble burning, but yet in the year 2014, as mentioned in my compendium, the central government rolled out a policy, National Policy for Crop Residues 2014, where it says that, your ladyship, it is obvious for national reasons that they can't roll out an act. So hence they came up with a policy, the central government. It says that we restrain from the practice of stubble burning. We central government, we would provide you 600 crores back in the year 2014, your ladyship, whereby in situ methods of crop residue management can be done, ex situ method of crop residue management can be done. Your ladyship, even after so many things, there has been no initiative from the part of the learned opposite counsel, and hence over here, as a counsel for plaintiff and petitioner, I am invoking the original jurisdiction under Article 131, your ladyship. That is my humble submission. If your ladyship may permit, may I please move on to 1.2 issue, which talks about the maintainability of the writ petition. The writ petition, it is filed by the Delhi Youth Climate Association, was against the state of Punjab. Here, your ladyship, I would like to dwell upon the factual matrix to prove the maintainability. Your ladyship, if you may please peruse through the Moot proposition. Again, paragraph 2, page number 15. Paragraph 2, page number 15. Your ladyship, the fourth line, the last word. Emissions arising from agriculture have found to have grown 6 times over the last 2 months. Your ladyship, the agricultural pollution percentage as per this report is 18. And this has grown 6 times in the last 2 months, and that is because of various air pollution reasons. that that is assisting agricultural pollution. Your Ladyship, my humble submission is that if 6% can be grown in just 2 months, how can we say that 18% is negligible? Your Ladyship, I would contend that even though the industrial pollution is 35% and vehicular pollution is 13%, improper waste disposal is 19%. Your Ladyship, you may ask me that agricultural pollution is negligible, it is only 18%. But the counsel for the petitioner would like to humbly submit that the very next line says that how proportionally it has grown in just a very small period of time. And hence it is a matter of concern. And hence the second case, the writ petition filed by the Devi Youth Association against the state of Pundideep is maintainable. Because it is a matter of concern, Your Ladyship. Your Ladyship, moving on to the third sub-issue, that is whether the writ petition number 3154 is maintainable. Your Ladyship, over here I'll be representing the Pundideep Agricultural Society. Your Ladyship, I would like to address the point that both the state of Dehaya and the state of Pundideep, Your Ladyship, were part of the same state under the name and style Vijaya. This particular state of Vijaya, it was further redivided into the state of Dehaya and Pundideep. Now, Your Ladyship, the factual matrix is clear in the assumptions that redistribution of land has not taken place. That is to say that the farmers having lands in this side of the state are still the owners. And the farmers having in this side of the state are still the owners. Redistribution of land is not happened. Your Ladyship, I would like to give you a submit before this honorable court hypothetical situation. Redistribution of land is not taking place. Imagine when the state was just Vijaya, there was a farmer who had a piece of land at the border. Your Ladyship, there is no scientific method to curb fire. Over here in Pundideep, it is legal. There is no law curbing stubble burning. I start a fire from here. For natural reasons, it passes on to the state of Dehaya. Now, who is to be blamed, Your Ladyship? Redistribution has not taken place. And now in the year 2016, they come up with a notification prohibiting the practice of stubble burning. And in 2023, they come up with a legislation entirely prohibiting. Your Ladyship, my farmers, this country of India, it is a 50% agrarian country. When that is the case, arresting the farmers is more or less like picking one's own tooth. Your Ladyship, it is humbly submitted that redistribution of land has not taken place, and the marginal farmers, the farmers who are in dire poverty, who are just having 1 acre of a piece of land, 2 acres of a piece of land, what is the other measures are available for them? Your Ladyship, it is humbly submitted that this particular legislation is a draconian legislation passed in the year 2023 by the state of Dehaya. Apart from that, Your Ladyship, in the year 2016, the notification which was also published in the official gazette is also draconian. And the trials which are now subsisting and the farmers are under trial, it is not even subsisting, Your Ladyship. And hence I would like to move on to the issue 1.4, Your Ladyship, which talks about the maintainability of the writ petition which is filed by us, that is my client, National Standards Broadcasting Authority, against the state of Dehaya.
Then before you go to that question, there was a question posed to you on OGT versus Article 32. I want to pose another question. Why not a 226 before the High Court and why 34? Why do you think that we should exercise this jurisdiction? You can very well go to the High Court.
Yes. Your Ladyship, answering to this, I might file a case because the stubble burning is starting from the state of Pundideep. I would resort to the jurisdiction of the state of the High Court of Pundideep under Article 226, as your Ladyship says. Your Ladyship, the Council for Petitioner believes that there may be a certain amount of bias on the central government, on the judiciary. Your Ladyship, when that is the case, it is my opinion that I wouldn't resort under Article 226 to the High Court of Pundideep.
The question is that did you even think of trying other than the political reasons that you mentioned? Because this looks like, from a bench's perspective, this looks like a political fight between two states which got into the Supreme Court.
Your Lordship, deepest apologies that you are assuming that is a political party, but it is.
You just said it.
No.
You said bias. You used the word bias.
You can't impute bias on judicial matter.
We'll not assume anymore.
Your Ladyship, it is just that the Article 139A of the Constitution of India, which was inserted by the 42nd Amendment Act, it says about the transfer of cases. Your Ladyship, the Supreme Court it has various versatile powers to hear matters, and the constitution, the charter document.
What is the basis of this statement that Supreme Court has wide powers to hear variety of matters?
Article 139A. Sir, 139.
Can you read it, please?
Yes, sir. Article 139A. Transfer of certain cases.
Before you start, this is not a question of a transfer. This is an original jurisdiction that you are in.
So I'm arguing about the writ petitions right now, Your Ladyship.
Yeah, so 139A deals with transfer of cases. And it
Yes,
doesn't
sir.
deal with original jurisdiction.
You invoke 32.
Yes.
You invoke 131 for suit and 32 for Supreme Court.
Yes, Your Ladyship.
Transfer would be that if you had filed it before the High Court and then asked for a transfer to Supreme Court.
Indeed, Your Ladyship. Over here, the dispute, the substantial question of law in the original suit is the same as the other three writ petition. Your Ladyship, it is conspicuously clear that it all relates to stubble burning and the deteriorated health conditions of the people.
That's not the answer. Answer is something that predicts Supreme Court.
Your Ladyship, Article 139A, it reads, where cases involving the same or substantially the same question of laws. It involves around the substantial question of law, Your Ladyship.
No, but that's precisely my point. Can a Supreme Court club the matters together or hear those matters together which have distinct reliefs and nature of subject matter of distinct?
Your Ladyship, over here, out of 4 cases, 2 cases relate to the deteriorated health conditions of
Answer
the
my question in one line. Hear me, hear my question. All the matters that have been clubbed today before us, are you saying that they are all similar in nature, subject matter is the same, and the nature of relief is also the same? Yes, yes or no?
similar in nature, Your Ladyship.
Nature of relief and the subject matter.
Yes, similar. Not entirely, similar to some extent. That is the reason I'm humbly contending as the counsel for petitioner that this particular matter, the 4 cases, may be clubbed together and heard together, Your Ladyship.
Have you argued or mentioned anything about 139A in your submission?
Your Ladyship, I've not mentioned 139A in my pleadings, but yet,
Do you have the constitution?
yes, Your Ladyship.
Please read 139A.
139.
Let me read it first. Where cases involving the same or substantial same question of law are pending before the Supreme Court and one or more of the High Courts. So are you saying that matter 32 that you have filed here or the suit that you have instituted before Supreme Court, this has something to do with other matters or suits or petition pending in different High Courts and therefore you are asking for a transfer of those cases here, or these are standalone 4 cases filed before the Supreme Court? Because transfer is we have been trying to tell you, transfer is a different jurisdiction. This is not a case of transfer, is what we are trying to tell you.
Yes, Your Ladyship, indeed accepted. If I just have few seconds, Your Ladyship.
All your time. Thank you.
Collect your thoughts. Don't go by what we are saying.
Don't worry.
Go ahead with your submission, we are just trying to test your argument.
Your Ladyship, the same article, Your Ladyship. The last line, it says that the Supreme Court may dispose of all the cases itself. The first line starts saying that where cases involving the same or substantially the same question of law are pending before the Supreme Court. Over here, all the 4 cases are filed and pending before this Honorable Court. And the last line also says that it may dispose of it by itself.
Okay, now you read the third.
Provided that the Supreme Court may, after determining the said question of law, return any case so withdrawn together with a copy of its judgment.
No. 139A1, where cases involving the second, third, and one of the High Court or both of the High Court, and Supreme Court is satisfied on its own motion or an application made by the Attorney General of your jurisdiction or by a party to such case that such question or substantial question of general importance. Now, is your case that this is a substantial question of general importance and all the cases pending in the entire country should be transferred to the Supreme Court and heard together? Or is it okay that these 4 cases you filed before the Supreme Court? Either of pick and choose one of the situations.
Your Ladyship, I am choosing that these are 4 standalone cases filed in this Honorable Court,
Correct.
and hence, since they involve the same substantial question of law, they may be heard together and disposed of together.
Okay, that's a different argument. It's not 139A, is what we are trying to tell you.
Apologies, Your Ladyship.
Anyway, we can move on.
Yes, Your Ladyship. The next sub-issue, sorry, as I've already addressed 1.5, Your Ladyship, I'll be continuing with issue number 4 and the co-counsel will be dealing with issue number 2. If you are satisfied with the issue number 1, Your Ladyship, I may please move on with issue number 4.
Please go.
Much appreciated.
What's the issue number 2?
Your Ladyship, the issue number 2, it talks about the arrest which is being made by the state of Devi against the farmers and whether arresting of such person is sustainable in law.
My question is that pertaining to issue 3, the state of Punjabi has been embarrassed for the issues of the residents of the Haya. What would the state of Punjabi do to the health of the farmers?
Your Ladyship,
Can't be prosecuted for doing the health of other people in the state without the residents of the one state.
just to confirm your question, Your Ladyship, you're asking that what has the state of Punjabi done to its own residents?
If you're talking about health hazards for neighboring states, of course your own residents are impacted first. Pertaining to issue
You can
3,
discuss.
whoever may want to
wants
answer.
say something.
Your Ladyship, the third issue, Your Ladyship, the third issue that you raised the question about, writ petition number 2345. It is filed by the Devi Youth Association against the state of Delhi. The question would be answered by the learned opposite counsel because we are not the state of Delhi. In this third issue, I am representing the state, not the state of Delhi, just the association, the Devi Youth Climate Association.
I'm just talking about the health hazards for everyone together in neighboring states because the border, the agricultural lands are cross border.
Your Ladyship, as concerned with my state, we have imposed a law in 2016 as well as in 2023. We have been following the central government's policy which was given in 2014, National Policy for Crop Residues, as well as this Honorable Court's judgment time and again. If you are satisfied with issue number 1, Your Ladyship, I please move on to issue number 4.
Yes, please continue.
I think let your learned friend do issue number 2 first.
As you may please, Your Ladyship. As you may please.
The officer seeks permission. Please.
Your Ladyship, I would be dealing with issue 2. Issue 2 talks about the writ petition 3154 of 2023, whether the action taken by the state of Bihar in arresting certain persons for engaging in stubble burning is sustainable in law. We, as a petitioner, are for Punjabi. It is respectfully submitted that it is not sustainable in law. Lordship, I would like you to refer to page number 34 of our compendium.
Sorry, who is the petitioner here? Punjabi Agriculture
Punjabi Agricultural Society.
Society. And who are the members of the society?
The factual matrix is silent about this. Para 16. 8th line. We are not at the moment considering the issue of adverse coercive measures like prosecution, etc. for offences under the AIR Act. This is the same act under which the state of Bihar have issued the notification and penalized the action of stubble burning. I would like you to refer to the factual matrix. Page 2, that is the page 15. Okay. Para 4. Para 4, in 2016, the state of Bihar under the AIR Act issued a gazette notification prohibiting stubble burning by traditional method, and the penalty therefore was 6 months, Your Ladyship. It it is respectfully submitted by the counsel for the petitioner that there arises no necessity to impose imprisonment, your ladyship, for the farmers who are indulged in stubble burning.
Counsel, one question. So these arrests were made under which law? Which state law?
The higher state law.
Okay, and can you show me where in the fact sheet it's mentioned that the arrests that were made were not under the law which was applicable to Kottidi?
There is no such law which is applicable to Kundidi, your
Okay,
ladyship.
so this, can you show me which law it was in the factual matrix where I will be this from?
Para 4 of the page 2, para 4 of the factual matrix.
Page?
Page 15, sir.
15 at the bottom.
At the bottom, para 4.
Last paragraph.
Last paragraph,
Can you read it?
fourth line. In 2016, the state of Bihar under the AIR Act issued a gazette notification, the 2016 notification, under section 19, prohibiting stubble burning by traditional method, and the penalty therefore was 6 months. Certain such farmers having land across borders were arrested by the state police of Bihar and are now subject to trial.
Okay. And, okay, proceed.
Uh, Your Ladyship, I would like you to refer to the National Policy for Management of Crop Residues, page 39 of our compendium. This is the policy issued by the central government in 2014, Your Ladyship. Before the notification which was being issued by the state of Bihar. Fourth point, strategy. The central government in this strategy have given 5 strategies to curb with stubble burning. None of them mention penalizing it. Even the central government, while forming the policy, have eschewed the penalty provision for stubble burning, Your Ladyship. Hence, it is respectfully submitted that is over and above clear that there is no intention to prohibit and ban stubble burning, and imposing imprisonment on the violators is strictly studied by the central government. Bishop, I would like you to refer to Commission for Air Quality Management Act 2021. No. Referring to the Commission of Air Quality Management in National Capital Region Adjoining Areas Act. Page 11, section 15. Section 15. Environmental compensation. The Commission may impose and collect environmental compensation from farmers causing air pollution by stubble burning at such rate, in such manner as may be prescribed. Even the Act which was passed in 2021 is talking about compensation. Even the policy which I have mentioned earlier is not talking about penalizing. Hence, I am contending that the arrest which the state has done of the farmers is not valid.
Counsel, do you think individual liberty is absolute?
Of
Talking about the arrest of these farmers,
Yes.
asking a general question. Do you think that individual liberty is absolute?
yes.
Is absolute. And if there is a case where there is public interest versus private interest or individual liberty, which would prevail?
Public interest.
Public interest.
So, Your Lordship, I would like to conclude this issue. Even though the agriculture is the state subject, and it's for the state to deliberate and legislate on the concept of agriculture, public health and sanitation, the state cannot assume monarchy and dictatorship and legislate any draconian law like in the present case the state has done. So if your ladyship is satisfied with the issue, I would move further to issue 3. Issue 3, writ petition number 2345 of 2023. It talks about whether, as per the established principles of environmental law, the state of Pundideep can be held liable for exacerbating the health issues of the residents of Bihar. Being the petitioner here, I will be arguing for the state of Bihar Youth for Climate Justice. It is respectfully submitted that not only as per the established principles of environment law, even as per the fundamental rights of life under Article 21 and other laws of the state of Pundideep, shall be held liable for exacerbating the health issues of the residents of Bihar. Your Ladyship, I would like to quote Atharvaveda here. I would like to read, man's paradise is on earth. The living world is the beloved place of all. It has the blessings of nature's bounties, live in a lovely spirit. Earth is a paradise and it's our duty to protect our paradise. The Constitution of India embodies the framework of protection and preservation of nature without which life cannot be enjoyed. Even Article 51AG of the Indian Constitution says it shall be the duty of every citizen to protect and improve natural environment including forest, lake, river and wildlife, and to have compassion for living creatures. Your Ladyship, I would like to mention again that the smoke-filled air due to the practice of stubble burning by the state of Pundideep have led to cause serious effect on the life of people in the state of Bihar.
Council, just one question on this. You refer to Article 21, right?
Yes.
But I think you are ignoring a very important article in the Constitution, which is 19(1)(g). The farmers also have a right to practice their occupation the way they want. And don't you think that you should be addressing that as well? 19(1)(g).
Your Ladyship, to answer that, indeed they have the right to livelihood, but there are some reasonable restrictions as procedure established by law. The Constitution provides the right to livelihood, but the same Constitution allows the state to strip down if there is some procedure established by law. As per the notification and the act which has been declared by our state, it is a procedure established by law. It is the state of Pundideep which is violating the right to life of our citizens.
Can you point out from the Constitution what are the grounds which are available on which 19(1)(g) is it can be curbed or there can be restrictions on that?
Your Ladyship.
19 deals with 19.
Nothing in the subclause G, nothing in the subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of right conferred by this said subclause, and in particular nothing in the said subclause shall be affect the operation of any existing law. So there is a law which has been declared by our state. And as my council said, the pollution percentage has been growing 6 times over the last 2 months. So it can't be neglected. I would like you to refer the case of Shanti Star Builders versus Narayan Lotane, page 114, para 9 of our complaint. Page 114, para 9. Are there options with me? Second line, the right to life is guaranteed in any civilized society that would take within its sweep the right to food, the right to clothing, the right to decent environment, and a reasonable accommodation to live in. And even in the case of Subhash Kumar versus State of Bihar, page number 120 of our compendium, the last para, page 120. Right to live is a fundamental right under Article 21 of the Constitution, and it includes the right of enjoyment of pollution-free water and air for all enjoyment of life. If anything endangers or impairs that quality of life in derivation of law, a citizen has right to have recourse to Article 32 for removing the pollution of water or air which may be determined to quality of life. Your Ladyship, I would like you to refer to the EPSA.
EPCA report.
EPSA. EPSA. Page 4. Page 4, EPSA. Last para. The Honorable Supreme Court had during the stubble burning period of October-November 2019 monitored the situation closely and directed state governments to take firm action. I would like you to note firm action against the fires. Even after that, our learned council state has not taken any action or passed any law regarding the banning of stubble burning. Litigation. Even in the case of MC Mehta versus Union of India, page 25 of our commentary. Sorry, Your Ladyship, I would like you to serve this compendium for me. Because the case is in there. Page 25.
Page 20.
5. Para 56. Page 25, para 56, second line. In the case of ANZ Greenlands Bank versus Commercial MCD Code, similar words are referred to decision of this code, observing that the word environment is a broad spectrum which bring within its ambit hygienic atmosphere and ecological balance. It is therefore not only the duty of the state but also the duty of every citizen to maintain hygienic environment. There is constitutional imperative on the state government and the municipalities not only to ensure and safeguard proper environment but also an imperative duty to take adequate measures to promote, protect and improve both the man-made and natural environment. And the same judgment, para 53, page number 24. In para 53, despite its difficulty, the court cannot remain a mute spectator when the violations also affect the environment and healthy living of the law abiders. Your Ladyship, I would like to conclude this issue by saying that despite various judgments of this Honorable Court and various commission reports of the central government, the state has not brought any law or any notification to curb stubble burning.
Council, just one question. So in farming, this is a very traditional and essential practice, stubble burning. And this is also included in the right to, under 19G, right to carry trade, do their work, business, etc. So you're talking about health of individuals and the right to life. So if there is a conflict, then what do you think, which one is the 21 or 19G?
21 should be considered first, Your Ladyship. Right to life is like, but if right 91G has some reasonable restrictions, so in the present case, Article 21 should be considered. Upper hand.
This is for the statement, like where is it written?
I have just now read that Article 91.
No, that I know what it says. Any judgment or any interpret what you are saying that it should be considered over, like 21 precedes 19.
At the current moment, I don't have any judgment verification.
So only.
Just one last question. Of course, you have referred to so many decisions which say that health is paramount and all of that. But isn't it that your state also would have certain industries, vehicles running on the roads, and your own report that you've cited says that many a times the share of crop residue burning is 4%. 4%.
In industrial pollution, 35%.
Correct. So by that logic, your state should stop all industrial activity because 21 is paramount, isn't it?
We are taking necessary actions. We have started with the farming and we have passed notification. We have recently in 2023 passed an act of stubble burning. We are taking necessary actions, Your Ladyship.
So it's a collective responsibility is what you're suggesting. So can you blame the other state for it? And
No,
will they be solely responsible for it?
It is not solely responsible, but they are not taking any action against it despite from the judgments given by this honorable court since the year 2014, Your Ladyship.
Thank you.
If you are satisfied with this issue, I would like to call counsel for issue 4. Yeah.
Just be mindful of the time.
Yes, Your Ladyship.
How much is left?
If I may, Your Ladyship, may I please proceed with issue number 4. Your Ladyship, the issue number 4 deals with whether the conduct of the Devi news channels violates the principles enunciated by statutory and regulatory authorities for the regulation of news and media content. Your Ladyship, I am the petitioner, counsel for the petitioner here, and the petitioner is the News Broadcasting Standards Authority. Your Ladyship, now the issue is very simple. The issue deals whether any particular principles laid down by the statutory or regulatory authority relating to news and media content have been violated. Your Ladyship, this court might be aware of the counsel petitioner just appraising this court about the relevant news and media statutes. It is the Press Council of India Act. Second one is the Cable Television Regulation Act 1995, the Cable Television Regulation Rules 1994. Your Ladyship, the issue deals with whether the Devi news channels wholly controlled by the state of Devi are violated. Your Ladyship, the state of Devi through their news channels have defamed the petitioner here, not the petitioner as well as the state of Devi by calling them backward in science as well as they are unaware of the massive issue of climate change. Your Ladyship, I would just like to place emphasis on both the Cable Television Networks Regulation Act as well as the Cable Television Networks Rules, Network Rules 1994.
You mentioned some allegation. Where is that allegation?
Which allegation?
Just referring.
That is contained in the Moot proposition. The Moot proposition. The Moot proposition clearly states that the state of Devi news channels, they have said that Pundideep is backward in science and they are unaware of the massive climate issue.
But is it not a case? Is it not a case of defamation then? You should be filing. You will file a writ petition. I want to understand. Please crystallize what exactly your allegation is and what your counter is. As in, what is the conduct of the news 8 channels that you are saying in this, and what is your answer to it without getting into the nitty-gritties of what regulations have been determined.
Your Ladyship, as you asked, I have not filed a suit for defamation because over here the argument, the contention is about the 4 news channels which are wholly controlled, which are owned and controlled by the state. As you may be well aware, Your Ladyship, under Article 12, the state is defined. Over here, Your Ladyship, by calling a state being backward in science, they have breached the fundamental rights of the citizens of the Pundideep, the authorities, and hence, instead of filing a defamation suit, we have approached this honorable court with a writ petition because the fundamental rights have been violated.
Please go to page 20 of your submission.
Yes, Your Ladyship.
The last paragraph.
The third paragraph,
Yes, Your Ladyship.
you clearly mentioned decency or morality or related to contempt of court, defamation or inciting to an offense. In this case, so and so have threatened to defame the state of Pondicherry and have caused a communal disharmony.
Yes.
That's what my question was without even reading your submission, that why not a stay, why not a suit under 131 before this court of defamation or and by a reputation.
Indeed, Your Ladyship. Your Ladyship, in the gist, the Cable Television Regulation Act under Section 5, it elucidates about program code. The section says that nobody can transmit anything which is in the violation of the program code. Now, this particular term, program code, is elucidated under the Cable Television Networks Regulation Rules 1994. Your Ladyship, for your perusal, I will please submit to you the rules. Your Ladyship, the third page, the very third page, rule number 6, it elucidates about program code. Particularly, I would like the honorable bench to look at M clause. Contains visuals or words which reflect a slandering, ironical, and snobbish attitude in the portrayal of certain ethnic, linguistic, and regional groups. In this particular case, Your Ladyship, we are dealing about two states, two regional places, and the news which is being telecasted by the Delhi news channels calling the state of Pondicherry to be backward in science and unaware of the issue is a politically propaganda news which is causing regional disharmony. Your Ladyship, this rules, which is a statutory principle which governs the entire satellite TV, it clearly says that you may not telecast anything which is violating the program code. The clause M says if anything is against the regional group, any particular word or visual, then such thing shall be taken down. That is my humble contention, Your Ladyship. Over here, calling a state backward in science, calling them unaware, is a serious case of slandering, Your Ladyship, and hence the Council of Petitioner have resorted to this honorable court for seeking resort.
Please see section 14.
Yes, Your Ladyship. The Rule 14 talks about the dispute resolution mechanism. It states every multi-system operator shall be obliged to maintain the quality of service
As the case may be determined by a regulation or order by the authority. Which authority is this? The authority referred to, do you know?
Yes, indeed, Your Ladyship. For your perusal, I may give this is of I couldn't find the court copy, the office copy. Section 19. Section 19 of this Cable Television Regulation Act 1995, Section 19 elucidates about the authorized persons, authorized officer. The authorized officer is an authority who is appointed by the Press Council of India Act.
So why are you there? That's the question.
Yes, Your Ladyship. Your Ladyship, a program is published, a particular content is telecasted. Over here, Your Ladyship, the Press Council of India, the Press Council of India, they have formulated committees to say Environmental Electronical Protection Monitoring Committee in the district level, state level, and they are even given powers to an authorized officer. Even after appointing such people, formulating such committees, the state of their news channels are still flagrantly publishing and flagrantly they are publicizing, flagrantly telecasting such content. They have failed to do their duty, and hence I have no other option, rather to come to this honorable court. Your Ladyship, the same act, it appoints the authorized officer. The section 20, if you may peruse through the act, it says that the central government, it has the authority suo motu to remove.
Alright, you can conclude your point.
Your Ladyship, to conclude, the issue is very simple. It's very clearly stating about whether any statutory or regulatory authorities law has been violated. As per the as the counsel for the petitioner, I have appraised this honorable court regarding the act and relevant statute. Hence, it is humbly submitted that you may please have a look at it and please grant us appropriately. If you are satisfied, Your Ladyship, may I please move on with prayer.
Yeah, please.
it is most humbly prayed, in light of the issues raised, arguments advanced, and authorities cited, that this honorable court may be pleased to adjudge and declare that all the cases should be heard together. The writ petition number 3154 of 2023 and writ petition 3728 shall be dismissed. The action taken by the state of Devi in arresting certain persons for engaging in the stubble burning is not sustainable in law. The state of Pundideep should be held liable for exacerbating the health issues of the residents of Devi. The conduct of the Devian news channels has violated the principles enunciated by statutory and regulatory authorities for the regulation of news and media content, and pass any or other order as the court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioners shall be duty bound ever humbly.
There's one last question, sorry. Your prayer B says that the two writ petitions shall be dismissed as being infructuous. So why have you mentioned this?
Yes, Your Ladyship. Your Ladyship, as I stated in the very beginning of my argument, that there is conflicting arguments that we made. We are the counsel for petitioner. I filed an original suit, I filed a writ petition. The state of Pundideep, they have filed 2 cases. But yet, the conflicting of arguments, I can't say that everything is maintainable. When I conclude as the counsel for petitioner, as the state of Devi was the first to file a suit and the first to file a writ petition, logically, as per the rule book of this honorable court, we might be the petitioners before the plaintiff. Hence, for the same reason, I've just quoted those which have been filed with the other side as to be dismissed.
You concluded your prayer by saying in the interest of justice, equity, and good conscience. What is good conscience?
Your Ladyship, good conscience just means that something that deals with morality. Law aspect, moral aspect are 2 different facets of jurisprudence. A particular action may be legally wrong, morally right, or the vice versa. The principles of justice, equity, good conscience talks about this jurisprudence that evolved the entire legislation, the mother document, constitution, and everything.
Thank you.
Much appreciated.
Thank you.
The council seeks permission to approach the dais. Much obliged.
You don't have a mic there. This one. There's a mic.
Greetings to the bench.
Fine, you're comfortable with this? Whatever you prefer.
You can come there.
Sure, sure.
Thank you, Your Lordship.
Petitioner respondent, placard. Or DP should be there.
Don't start the timer.
council seeks permission to oppose election. Much obliged. Greetings to the bench. The council seeks permission to address the bench collectively as a lordship. Much obliged, Your Lordship. May it please Your Lordship, this is council number 1 standing on behalf of the respondents in the present dispute. Council number 1 shall be dealing with issues 1 and 2 and shall be taking 35 minutes of the honorable court's time. My co-counsel shall be dealing with issues 3 and 4 and shall be taking another 23 minutes. With the leave of this honorable court, we humbly reserve 2 minutes for rebuttals and surrebuttals. Your Lordships, if there are no preliminary inquiries, the council would like to proceed with the issues. Much obliged, Your Lordships. Your Lordships, the counsel for the petitioners have approached this Honorable Supreme Court of India under Article 131 invoking original jurisdiction and Article 32 that is writ jurisdiction of the Honorable Supreme Court of India. Your Lordship, the first issue primarily pertains to whether the petitions are maintainable and can be heard together. Your Lordship, the counsel for the respondents humbly submits that the petitions are not maintainable and cannot be heard together, and this will be dealt in three-pronged argument. Firstly, Your Lordships, there is no absolute violation of fundamental rights in the present cases, and the dispute doesn't concern two states per se, it concerns the people of the states. Your Lordships, secondly, the alternative remedy is available under Article 226 following the doctrine of judicial hierarchy and under the NGT Act 2010. Thirdly, Your Lordships, the petitions cannot be heard together and cannot be consolidated together since the nature, facts and laws applicable to the petitions are distinct and different. Your Lordships, if there are no preliminary inquiries, the council would like to proceed with the first round of hearing.
I have a question. In the suit, in the suit, have you ever, did you, your submissions cover the points on 711 or anything to do with rejection of the plaint?
Apologies.
Rejection of the plaint on the basis of there being no cause of action. Have you made that as a submission of yours?
Your Lordship, the written submissions doesn't deal with it. The written submissions deal with the alternative remedy.
Alright.
However, the compendium deals with some judgments, landmark judgments, which states that if there are no absolute violation of fundamental rights, the writ jurisdiction can't be used. Indeed, Your Lordship. Your Lordship, the council humbly submits that there is no absolute violation of fundamental rights. Therefore, the writ petitions under Article 32 of the Constitution invoking writ jurisdiction of the Honorable Supreme Court of India can't be used.
You're right, they should have gone to the High Court under 226.
Indeed, Your Lordship.
Okay. And what is the difference between 226 and 32?
Your Lordship's Article 226 is much wider in application than Article 32.
In what sense?
Indeed, Your Lordships, Article 32 states and gives the powers to the Honorable Supreme Court to issue writs in case of violation of fundamental rights. Your Lordships, under Article 226, it is much wider in application as it gives the power to the High Courts to issue directions, orders and writs. Therefore, it is much wider in application than Article 32, Your Lordship.
So you are saying in addition to the violation of fundamental rights, you can approach for other things also to the High Court under 226.
Your Lordship, for the violation of fundamental rights per se, the writ jurisdiction will be invoked under Article 2.
No, but if there is a violation of a legal right, can you then approach 226?
Your Lordship, only for the violation of fundamental rights. There may be some legal rights that can overlap with the fundamental rights, but if there is per se violation of a legal right, they can't approach under Article 226 because under Article 226, the writ jurisdiction can be invoked if there is a violation of fundamental rights.
But you said that 226 and 52 are different in scope. 226 is wider.
Indeed.
In what aspect is it wider? That's
Indeed,
the
Your
question.
Lordship. Your Lordship, Article 226 says that the High Court can issue directions, orders as well as writs. Whereas Article 32 gives powers to the Supreme Court to issue only writs. That is why it is much
May I
wider.
draw your attention to Article 32 once?
Indeed, Your Lordship.
Just read 32(2). Rather read 32(1) and 2 both.
Article 32, remedies for enforcement of rights conferred by this part. the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed.
Right.
Second,
Which is the rights in this part, right? Then
Indeed, Your
second.
Lordship. 32 clause second, the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and
You
certiorari.
can stop here. So this article also mentions directions, orders, or writs up to 226.
Indeed, Your Lordship.
Yes. By the time you compare this language view, power of high courts to issue certain writs. Notwithstanding anything in Article 32, every high court shall have powers throughout the territories in relation to which it exercises jurisdiction.
Indeed, Your Lordship.
So does the high court in one state have jurisdiction over the subjects of the other state?
Your Lordships, the concerned High Court must be approached. If there is a violation pertaining to the rights of a certain state, the concerned High Court of that particular state should be approached.
All right. Now, what my learned brother was asking the question, just read ahead. I think it will answer your question.
Indeed, Your Lordship.
Yeah, including writs in the nature of habeas corpus. It has the same language, right?
Indeed, Your Lordship.
And it says for enforcement of any rights conferred by Part 3 and for any other purpose.
Indeed, Your
Yeah,
Lordship.
that's the difference between 32 and 226. And therefore, you can approach the High Court for the fundamental right violations as well as the violation of any legal right.
Indeed, Your
That was the
Lordship.
question.
Apologies, Your Lordship. Your Lordship, there is no absolute violation of fundamental rights as mere, Your Lordship may refer to para 5 of the Moot proposition, where it states that emissions arising from agriculture are 18% of the pollution. Your Lordships, it is nowhere stated that how much percentage of pollution arising from stubble burning is a part of that 18% of agricultural pollution. That 18% agricultural pollution may come from other sources as well. There are fertilizers, there are various types of chemical fertilizers, pesticides being used while practicing agriculture, and there is nowhere stated in the factual metrics that how much percentage of that 18% is constituted by the practice of stubble burning. That is why, Your Lordship, there is no absolute violation of fundamental rights.
No, but according to you, what can be the other relevant factors for adding up to 18%? You are making an argument that it is not necessary that stubble burning is the 18%, is the entire 18%. Maybe 4%, 3%.
Indeed,
The
Your
remaining
Lordship.
15%, according to you, what that can be?
Indeed, Your Lordship. Your Lordship, there are various machineries being used while practicing agriculture. There may be emissions arising from the vehicles, like.
No, but vehicular pollution is separate head. It's a separate head. If you come to page 15 of this new proposition, paragraph 2, the third line, industrial pollution we can remove, but vehicular pollution is what we're talking about. But 18% of the agricultural pollution can be by use of thresher, use of tractors, etc.
Indeed,
right?
Your Lordship.
So that can be a percentage. But what is your, like they showed a report. Where is your report or your reference to the fact that you are saying that it can only be a fraction of this 18% and not the entire 18%?
Indeed, Your Lordship. Your Lordship, the other sources from which agricultural pollution can arise is the use of various chemical fertilizers, various chemical pesticides, and other sources. And stubble burning may constitute only a part of the agricultural pollution and not the agricultural pollution per se, which was the contention made by the learned counsel for the petitioners. Your Lordships, again.
In addition to that, I just want to ask that stubble burning is a part of the same procedure. So whether it is 4% or 18% is contributing, and it's a consequential outcome. So how it doesn't matter if it's 4%, 8%, 18%. It's a consequential outcome. So what do you have to say about that?
Indeed, Your Lordship. Your Lordship, the counsel for the respondents would like to clarify this point. Your Lordship, in para 5 of the Moot proposition, it is being stated that industrial pollution is 35%, vehicular pollution is 13%, improper waste disposal is 19%, and pollution caused by miscellaneous causes is 15%. And that is why agriculture pollution, which my fellow learned counsel for the petitioners were contending, is merely 18%, whereas the rest of the 82% of the population is being caused by other sources.
No, wait. Your argument is something else according to me. I have learned it separate. That agricultural pollution was 18% and stubble burning is a small fraction of agriculture pollution.
Indeed, Your
So let's
Lordship.
not talk about 82%.
Indeed, Your Lordship.
18% there is a fraction of stubble burning.
Indeed, Your Lordship.
Your answer has not come out yet whether it is 2%, 4%, or if that is your contention or your submission, what is the basis of your submission?
Your Lordship, the agricultural pollution is not caused by stubble burning per se, whereas it comes from other sources as well.
Okay, proceed.
Indeed, Your Lordship. Your Lordship, now there is further no right to reputation exists against the state. My fellow learned counsel for the petitioners have stated that the right to reputation have been violated in the fourth petition, and that is why they have approached the Honorable Supreme Court of India under Article 32, invoking writ jurisdiction as the right to reputation, which is a fundamental part of Article 21 of the Constitution, have been violated. It is to be humbly submitted before this Honorable Court that no right to reputation exists against a state. The petition.
What is the measure to ascertain the reputation of an individual or a state? What is the test?
Your Lordship, if a person makes a particular statement which is injurious to the reputation of the other person, say the person publicizes the statement that it comes to the notice of the other persons as well while publicizing, it can be injurious to the reputation
My
of the
question is, how do you ascertain reputation of an individual or a state?
Indeed, Your Lordship, the reputation of a person can be ascertained when the statement being made by one person has come to the knowledge of the other person. Further, when the statement being made has no element of truth in it, that is when the right to reputation.
Counsel, that you are defining in a way defamation. What my learned brother is asking is, how do you determine how do you quantify reputation firstly to say that it has been defamed?
Indeed, Your Lordship. Your Lordship, the word reputation has not been defined per se. The word reputation will differ from case to case and circumstances of the case. In one particular case, the word reputation may be defined differently, whereas in the other cases, according to the factual matrix of the case and according to the circumstances of the case, the word reputation can be defined differently.
So have you taken that as a ground in your statement to say that A, the reputation firstly has not been determined by them to say that it has been actually defamed, as some statement made by you?
Indeed, Your Lordship, the Lordship Counsel for the respondents would like to clarify this point. Your Lordship, it is being stated in the argument that no right to reputation exists against the state. It exists against the people, not the state. But the petition states that the petitioner in the particular petition, that is number 3728 of 2023, Your Lordship, it states that Your Lordship may refer.
I'll give you an example.
Indeed.
There's a state which is trying to attract investment, and somebody keeps on newspaper or any channel is writing against that state that it's the worst place for investment. There have been a flop show, nobody should invest there, and there's a huge reputational loss to that state.
Indeed, Your
And it has
Lordship.
affected the investment.
Indeed, Your Lordship.
You are saying they have no locus, they cannot do anything against this news channel
Your Lordship, when
because
it
there is
comes,
no reputation.
indeed, Your Lordship, when it comes to the writ petition under Article 32, they don't have the locus. The locus would be under under various other provisions such as defamation, but the locus can't be under.
But then they will have reputation. State can have reputation.
So you can't say that they don't have a right to be that.
Indeed, Your Lordships, various landmark judgments have stated that no right to reputation exists against the state, whereas.
Can you tell us one landmark judgment which said state does not have any, cannot file a case if there is a reputational loss?
Your Lordship, the landmark judgment of Sujit Pannu was a state of
Do you have
Punjab.
a copy?
Your Lordship, the council will apologize for this.
Various landmark judgments you said. Can you tell us any recent Supreme Court judgment which said so?
Your
You cited
Lordship,
in your memo.
Your Lordship, the written submissions doesn't deal with the, as stated earlier, doesn't deal with the first prong of the argument. It states about the alternative remedies, whereas the compendium states about the cases that when there is no absolute
Yes,
violation of
tell
law.
me any recent judgment and what does it say?
Your Lordship, the council will have to look into it.
So you said there are various judgments.
Indeed, Your
This
Lordship.
judgment that you were citing, what does it say?
Your Lordships, it states about right to reputation, which exists against the persons and not the people, and not the state. Indeed, Your Lordship. Your Lordship, with due permission of this court, the counsel for the respondents would like to present the compendium of cases as well. Indeed, Your Lordship. Your Lordships,
Do the patient need a copy of this by any chance or any lunch? You want? Give one copy to them. Generally also in courts you always ask for a copy.
should the counsel proceed, Your Lordships? Indeed, Your Lordships. Your Lordships, now doctrine of judicial hierarchy must be followed and the parties must approach the concerned High Court under Article 226 or NGT under the NGT Act 2010.
I have a question.
Indeed, Your
In your
Lordships.
compendium, the first case you have cited, page 1, Anwar Khan versus State of Rajasthan. There is a citation RLW. What does it mean?
Your Lordships, can the counsel take the compendium for the petitions for the time?
You are a keep this.
Your Lordships, the counsel will have to look into it. Indeed, Your Lordships. Your Lordships, the doctrine of judicial hierarchy says that when the courts have shared or concurrent subject matter over a particular case, they must first approach the concerned High Court under Article 226 rather than directly knocking the doors of.
What is the basis of this judicial hierarchy doctrine?
Your Lordship, the doctrine of Your Lordship, there are the structure of the country, the structure of the judicial institutions in the country are such that the
And
subordinate.
I'm aware.
Indeed,
What
Your
is the
Lordship.
doctrine? Is there a doctrine in the first place or you have coined this term?
Your Lordship, the doctrine exists in the first
That's
place.
what I'm asking. What is the basis? Where is it?
Your
How did it-
Lordship.
Yeah.
Indeed, Your Lordship. Your Lordship, in various landmark judgments, such as Kanubai Brahmavat versus State of Gujarat, Your Lordships may refer to footnote 7, page 2 of the written submissions. Your Lordships, the case the case must first be dealt with by the subordinate courts to the apex courts when there exists a shared jurisdiction on the subject matter of the case. Your Lordships, further, it is being stated that the counsel for the petitioners have alternative remedy under NGT, that is a National Green Tribunal. Your Lordships may refer to page 161 of the compendium, if Your Lordships are with me.
Tell us.
Your Lordship, Section 3 of the NGT Act 2010 states that the central government shall, by notification, establish with effect from such date as may be specified therein, a tribunal to be known as a National Green Tribunal to exercise the jurisdiction, powers and authority conferred on such tribunal by or under this Act.
You mentioned that if there is existence of an alternate remedy.
Indeed, Your Lordship.
Doctrine of election applies in such cases or not? That if you have elected one remedy, you can't be approaching the other. So you have to take a calculated call when approaching a court.
Indeed, Your Lordship. Your Lordship, say for example, in cases of maintenance as well, when it comes to the apex courts have said or emphasized time and again that a calculated approach must be taken while if there are alternative remedies to a certain issue.
Yeah, so if they have chosen Supreme Court and not NGT.
Indeed, Your Lordship.
They have elected Supreme Court.
Your Lordship, the counsel would like to differ with utmost reverence. With the great wisdom of this court, Your Lordship, the case should be of transcendental importance, national interest or seminal interest to approach under Article
This
30.
is not national interest.
Your Lordships, the dispute has concerns only two states as per the factual
Only
matrix.
two states.
As per the factual matrix, Your Lordship.
No. Only two states is not public importance. There has to be something affecting the whole country. Only then Supreme Court can come into the picture.
Your Lordship, again, the factual matrix says that the stubble burning is the factual matrix is silent on the part that how much percentage is stubble burning causing the pollution. And that is why it is not of transcendental importance and national
So that is
interest.
something we have to look into. But since it is concerning two states, it becomes a public issue. Whether it is actually affecting majority people, it's a small cause. That is to be looked into. But you can't say we don't have jurisdiction.
Indeed, Your Lordship. Your Lordship, the Council would like to clarify this point. Your Lordships, the matter that is of public issue and the matter that is transcendental importance of national interest are different. Public issue is different. The matter of national issue is different. The national issue may concern the country at large, not per se the two states. That is why, Your Lordships, it is being stated here and it is being humbly submitted by the Council of the Respondents that the matter here is not of national interest.
So you are saying national interest and public interest are separate?
Your Lordship, the two terms are separate and the national interest.
I'll simplify that for you. There's a difference. There's right to livelihood and there is right to life or liberty.
Indeed,
We're
Your
not,
Lordship.
I'm not saying which one precedes the other, that's for you to answer.
Indeed.
But how can you say that both of them or a singular one, even in two states or one state, are not of necessary public importance for the country at large? 18% pollution is almost 1/5 of the source of pollution. It doesn't matter, we're not talking about other pollutants, we're talking about 1/5 of the source of pollution. And then we're talking about right to livelihood and right to life or liberty. How is that not necessary public importance for a country?
Indeed, Your Lordship. According to the factual matrix, it concerns two states. Again, it states that agriculture pollution is caused by that emissions arising from agriculture is 18%. But again, it doesn't state that the terms stubble burning and the term agriculture pollution may not be overlapped here. Stubble burning is only
Let me ask a question from you on this particular aspect. You're coming back to the same answer.
Indeed, Your
Without
Lordship.
a data analysis of the same. So I think this argument is not flying well with the bench.
Yeah, I think we can proceed because stubble burning is a direct outcome of an agricultural practice, so you cannot separate them.
Your Lordship, indeed, we cannot separate them. The terms cannot be overlapped. Your Lordship, if there are no further inquiries, the Council would like to proceed. Indeed, Your
We
Lordship.
have only queries, no inquiries.
Much obliged, Your Lordship. Your Lordships, again, the petitions can't be clubbed together and consolidated together since the nature of the petitions is distinct and different. Your Lordships, the Council for the Respondents would humbly like to submit that the petition, and that is number 35 of 2023, is an original suit and invoking original jurisdiction under Article 131, and other petitions are invoked under Article 32 of the Constitution, that is writ jurisdiction. The nature of the petitions is entirely different. Further, Your Lordships, the third petition is a criminal writ petition which relates to the arrest, and therefore and the other petitions are civil petitions. Again, the nature of the petition is distinct and different. Further, Your Lordships, my fellow learned counsel for the petitioners have contended that there are same quotient of law and fact in these petitions. But Your Lordships, the facts of the petitions are different, the laws applicable to the petitions are different, therefore the petitions are entirely distinct and different in nature. Your Lordships,
Can you explain how the petitions are different? I think they're all the same because they're emanating from the same cause. You may have asked, there may be like differing or similar reliefs, not identical, but the stream of argument is the same in all of them and it's emanating from the same problem.
with utmost reverence, the Council would like to differ at this point. Your Lordship,
Please explain how the subject matter of each issue is different. We're not talking about the criminal or the civil angle, we're talking about the reasons and the emanating ground of it.
Indeed, Your Lordship. Your Lordship, the first issue pertains to Article 131 invoking original jurisdiction. Again, the applicable and the consolidation of suits. Again, the applicable rules can be Order 55, Rule 5 of Supreme Court rules, Section 151 of CPC, Article 142 of the Constitution, and Article 131 of the Constitution. The second petition relates to is filed by the Higher Youth of Climate Justice against the state of Punjab, and thus it may concern.
The council, I think. Okay, I went one step ahead. I'm
Indeed,
talking
Your
about
Lordship.
subject matter.
Indeed, Your Lordship.
I'm not talking about the
Clauses of the constitutional articles, how is the subject matter different? All four are the same.
Your Lordship, the Council would like to differ at this point. Your Lordship,
So are you saying the underlying, what my sister judge has asked you, that the underlying issue is not stubble burning? She is saying that that is the subject matter. Everything emanates from there.
Your Lordship, but the cause of action may be stubble burning, but the
But do
facts.
you agree to that extent that the root
Cause of
cause of all the issues is stubble burning?
Indeed, Your Lordship. Your Lordship, the Council for the Respondents will humbly submit that in the Sabrimala case, various petitions were clubbed together, but in that particular verdict, that various petitions related to only one issue, that is religion, and right to equality. That is why those particular petitions were clubbed together.
No, if you really see this argument, it's exactly what my sister judge is saying. That the cause of action, please understand, cause of action is one. It happened and therefore these remedies have emanated. Right?
Indeed, Your Lordship.
Suit is basis you have they have filed a suit asking you to stop stubble warning, do something else. Writ petition, defamation happened because the stubble warning issue happened and somebody called them backward or something else. So the cause of action is similar, is the question. Is the answer yes or no?
Your Lordship, the cause of action.
Or do you beg to differ again?
Your Lordship, the cause of action may be same, but the facts of the petitions are different. That is why the petitions are distinct in nature, and that is why they can't be consolidated together, as it can result in chaos in the administration of
Maybe the
justice.
relief is distinct.
The facts of the Your Lordship, the facts are distinct, the laws applicable are distinct, and therefore the relief claims are distinct as well. Your Lordship,
In Sabrimar also the cause of action was the same, the reliefs were different. There were issues of menstrual hygiene, right to liberty of women, Article 25 of the Constitution. They were different, but the cause of action was the same.
Apologies, Your Lordship.
So at the time of the court should be spent in deciding one cause of cases emanating out of one cause of action according to you being an officer of the court. You are a lawyer also, right? You're just not representing your party. So is it not better if we decide 4 cases together because the cause of action is the same and the relief ultimately somehow has some overlap? What is your view on it, independent of the fact that you're representing your party?
Your Lordship, the petitions must not be consolidated together, as the nature of the petitions is different. On the very first place, one petition relates to the original jurisdiction, the other 3 petitions relates to the writ jurisdiction. Further, one petition is of criminal writ petition, the other are of civil nature. That is why, Your Lordship, the petitions can't be consolidated.
Your duty is to the court or to your client?
Your Lordship, the council has the duty to the client as well as to the court as well.
So council, tell us one thing. If the matters are indeed clubbed together, what is the concern that you have?
Indeed, Your Lordship. Your Lordship, the concern is that the nature of the petitions is entirely
No,
different.
that's for us to decide. We will decide that.
Indeed,
But
Your
if
Lordship.
indeed they are clubbed together and we decide to adjudicate all these 4 suits and petitions together, what is your moot argument that it should not be clubbed together? I understood you are saying that the facts are different.
Indeed.
What is your apprehension, correct? What is it that you are apprehending that will go wrong?
Your Lordship, the laws applicable in these particular petitions are entirely different. That is why, if the petitions are being clubbed together, it will result in the miscarriage of justice. Your Lordship, that is why the petitions can't be clubbed together. Your Lordship, if there are no queries, the council would like to proceed with the second issue. Much obliged, Your Lordship. Your Lordship, the second issue pertains to whether the arrest made by the police of the Dihaya to the people of Pundidik sustainable in law. Your Lordship, the council, on behalf of the respondents, would humbly submit that the arrest is sustainable in law and it will be dealt under in a twofold argument. Your Lordship, firstly, the law under which the arrest is made applies to the state of Pundidik by the doctrine of territorial nexus. Secondly, individual liberty is not absolute in nature and collective well-being may supersede individual liberty. Your Lordship, firstly, the law under which the arrest is being made, that is Section 19, Air Prevention and Control of Pollution Act 2016. Your Lordship may refer to Para 7 of the Moot proposition. If your Lordships are with me. Much obliged, Your Lordship. Your Lordship, the law is applicable to the state of Pundidik as well by the doctrine of territorial nexus. Your Lordship's Article 245, Clause 1 of the Danubian Constitution states that the laws made by the state legislatures are applicable to the state. However, there is an exception to that rule, and which is a doctrine of territorial nexus. Your Lordships, in a very landmark judgment of Tata Iron and Steel Company versus Bihar State Tax Act, your Lordships may refer to footnote 37, page 8 of the written submissions, if your Lordships are with me. Much obliged, Your Lordships. Your Lordships, the elements of doctrine of territorial nexus were laid down in this particular case. It was stated that the connection must be real and illusory, and the liabilities sought to be imposed must be pertinent to that connection. Your Lordship, it is humbly submitted that both the elements of the doctrine of territorial nexus are fulfilled in the present case, and therefore the law under which the arrest have been made is sustainable in law. Your Lordship, the second prong of the argument deals with that the individual liberty is not absolute in nature and collective well-being may supersede individual liberty. Your Lordship, there is a distinction between liberty and freedom. Liberty comes with licenses, whereas freedom is without license. Your Lordship, individual liberty is not absolute in nature. It comes with licenses, and sometimes sometimes collective well-being has to supersede individual liberty. Your Lordship, in the instant petition is challenged on the grounds by the petitioners that it is a curtailment of the right to livelihood under Article 21 of the Indian Constitution, as it deprives them of their liberty and thus the capacity to earn livelihood. However, it is to be kept in mind that
Whose individual liberty you're talking about?
Your Lordship, there are different petitions and therefore they are being dealt differently.
That's what I'm asking. Whose individual liberty you're talking about? Because I know there are multiple petitions.
Your Lordship, that can be answered according to different petitions.
Which one are you addressing at the moment?
Your Lordship, this is a collective argument that in all the petitions, since individual liberty is not absolute, collective well-being
Are
is
you talking about those arrests that were made?
in this particular point of my argument, indeed, Your Lordship.
How many people were arrested?
Your Lordship, the factual matrix is silent
A group
about.
of people.
Indeed, Your Lordship.
How
Your Lordship, the people were arrested who have lands in both the states. Indeed, Your Lordship.
Not just one person, it will be a lot of people. Right?
Indeed, Your Lordship.
So how do you say individual liberty?
Your Lordship, individual liberty in a sense that the petition has been challenged on the grounds that the farmers cannot practice their livelihood, cannot practice their occupation, and that is why they are being deprived of their livelihood. Now, Your Lordship, if the farmers are taken as an individual unit, the group of...
Do you think individual liberty means a group can be treated as a single group?
The council would like to differ. Your Lordships,
No, I'm asking a question. You have to differ with me. I'm not making a statement.
no, Your Lordship, the farmers who were arrested, if they are led individually, they have stated that the livelihood of the farmers is being violated. Your Lordship, in that instant petition, individual liberty is not absolute and collective well-being may supersede as.
So collective well-being of these people who are arrested.
No, Your Lordship, the collective well-being of the people of the state of Bihar who are being impacted, as their health and well-being is being impacted by the practice of stubble burning.
No, but farmers are also a group. Public interest of the farmer.
Indeed, Your Lordship.
Why are you treating that as an individual liberty and not a public interest?
Indeed, Your Lordship. Your Lordship, as the farmers are arrested collectively, but they have been practicing their occupations individually. Your Lordships, and collective.
Yeah, but people are also having health hazard individually. Individual health is being not that everybody.
Also as a group.
All those are group also.
Indeed, Your Lordships. The state of Pundizi for the impact of its farming practices on the health and well-being of the people of Bihar. So, people of Bihar, it concerns the whole of the state of
Yeah,
Bihar.
it's a group of people residing there, residents of this. Just like farmers, you are treating in one group as one unit.
Indeed, Your Lordship.
So residents of this state will be treated as one group.
However, Your Lordships, the farmers who have been arrested are less in number than.
Also, number determines whether it's individual liberty or not.
Your Lordship, the number doesn't determine. Your Lordship, the whole of the state of the Haya is being impacted in that particular case. That is why the matter of collective well-being comes into play.
State of Bihar will also be impacted when all these farmers are arrested, and considering that 50% of the economic backbone of this country of India comes from agriculture, and you arrest these farmers. So the very food that these farmers are growing in a neighboring state is being consumed by the people of Bihar. So then again, there are overlapping interests of individual liberty and overlapping collective conscience and collective well-being. How do you segregate that? Because food grown in one state is being consumed all over the place, and the health issues are also overlapping. If you're talking about territorial nexus, it flies both ways.
Indeed, Your Lordships. The Lordship, the factual matrix is completely silent upon that, and the answer to that question would make the counsel for the respondent as to the presumption of the facts. Your Lordship, if there are no further queries, the counsel would like to proceed with the argument.
Please.
Much obliged, Your Lordships. Your Lordships, for in the very landmark judgment of Hira Tipu versus Union Territory Chandigarh, Your Lordships may refer to page 49 of the compendium. If Your Lordships are with me. Your Lordships may also refer to footnote 44, page 10 of the written submissions made on behalf of the respondents. Your Lordships, it was held that the principle of public welfare is based on an implied agreement that individual welfare shall, in cases of necessity, take a backseat to give way to public welfare. Liberty and life under certain circumstances be jeopardized or even sacrificed for the public good. Your Lordship, that is why individual liberty is not absolute, and that is why the arrest is sustainable in law. Your Lordship, if there are no queries, my co-counsel shall be dealing with issues 3 and 4. Much obliged, Your Lordship. Thank you, Your Lordships. It was indeed an honor to argue before this court.
The council seeks permission to approach the dice. Much obliged. Greetings to the honorable bench. Today, I stand here in the Supreme Court of India as a co-counsel on behalf of respondents. In the course of my arguments, the council shall be addressing the honorable bench as your lordship individually and as your lordships collectively. With the due respect of your lordship, the council seeks to proceed ahead with the third and fourth issue of the case. Much obliged. Due to the paucity of time, the council shall be addressing the third and fourth issue of the case in a 17 minutes instead of taking 23 minutes. Your Lordship, in the course of my 18 minutes of my arguments, I intend to establish that firstly, as per the present factual matrix of the case, the state of Panditi cannot be held liable for excavating the health issue of the residents of Dehaya due to the intricacies of the profession followed by the farmers of the Panditi. Secondly, that the conduct of state news channel in the state of Dehaya is protected under these fundamental rights enshrined in the constitution as program was based on purely factual metrics. Your Lordship, if there is no preliminary inquiry, the council would like to proceed ahead with the first prong of the argument. Your Lordship, the council shall be submitting the first prong in first argument in two, namely, that is third issue of the case, that firstly the practice of such harvest disposal is an essential practice in the occupation of farming, and anything in immediate contravention to it would violation of freedom of carrying out trade and profession. Subsequently, with Article 21, which is right to life, which further constitutes the right to livelihood as well.
So even the diesel cars which are banned after 10 years, that is also essential practice going on for the longest time, affecting the trade and business of a lot of companies. Then just because it has been going on, it should continue. It cannot be banned.
Indeed, Your Lordship. Also, at the same time, it is present in the attention of the honorable bench that just apart from diesel cars, we have alternates to petrol or electric cars. But in the present factual matrix of the case, that the practice of stubble burning is an essential practice due to considering the time frame that is left to the farmers of Punditi. Your Lordship, it is humbly presented before this honorable bench that considering the time frame for crop cultivation, that is kharif crop that is harvested in the October, and sowing of rabi crop in the month of November, leaves only a time bracket of 1 month to the farmers of Panditi to harvest the crop, to clear the residue, and to re-fertilize the field. Your Lordship, in considering these factors, the stubble burning, which not only burn the stubbles left behind,
But also on the health of individuals.
Your Lordship, Your Lordship, it is further contended by the council and shall be addressing the same.
So council, you are saying that there is no alternative to stubble burning?
Your Lordship, it does have alternative measures. You may refer to para 47 of the written submission on behalf of respondent. The respondent has duly mentioned that there are alternative measures, but subsequently the time frame that we are considering that of only 1 month. First the harvesting of crop, then removal of stubble, and it is also presented that the stubble is root bound. That could be a time consuming process for the farmers who already belong to an agrarian country, which is already in throes of poverty, that couldn't afford the latest machinery. So your ladyship, considering all these factors, this stubble burning proves to be a cost and time efficient.
Does the state not have any responsibility to stop this? You are saying that there is no efficient mechanism available to stop this practice.
Indeed, Your Lordship, but also at the same time, the present factual matrix is silent on the same. But also at the present petition is filed on the banning of stubble burning. Your Lordship, it is acknowledged by the council that it does have repercussions on health, on air pollution, but it has to be addressed in a period of time. Just straightforwardly banning the stubble burning and arresting the peoples of Pondiri has to be in contravention of the right to livelihood. Your Lordship, if the practice of stubble burning is based on time period, the council acknowledges the same. But
So
but the
from
immediate
2014 is when elections were given.
Apologies, Your Lordship, for the review.
So from 2014, you are saying you haven't received enough time to be able to implement alternative measures. That's what the state is.
Your Lordship, considering the economic factors of the state and countries, which is explicitly mentioned in the Moot proposition itself, the state has to propose the alternate measures. But subsequently, in the para 48 of the written submission on behalf of respondent, it is presented already that the measures has been suggested, but due to the economic condition of the state of Denudia, it has proved to be an harbinger in implementation of such alternative usage. Indeed, with the due permission of Your Lordship, the council would like to proceed ahead. Indeed, Your Lordship. In furtherance, Your Lordship, it is presented that there is no concrete fact proving that smoke emitted by this stubble burning is the prime or even a significant contributor in the total pollution of the Dehaya. Your Lordship, please refer to para 5 of the proposition. As per the facts of the report, it is explicitly mentioned that agricultural waste contributes only 18%, and that is insignificant to the total pollution that emerges from the domestic causes in the state of Dehaya. Your Lordship, industrial pollution stands at 35%, near and dear to the double of what has been imputed on the people of Panditi. Your Lordship, you may refer to para 45 of the written submission on the behalf of respondent. Your Lordship, it is presented that agricultural pollution consists of discharged pesticides, fertilizers, organic matter, sediments, salt and air pollution caused by stubble burning. That too with the variation in an annual occurrence, which means it is not frequent or even a permanent issue solely due to the nature of the crop seasonal cycle. Your Lordship, the council would inquire if the honorable bench has any queries on their end. Indeed, Your Lordship, much obliged. Your Lordship, as per the case of D.K. Yadav versus JM Industries, Your Lordship, you may refer to. Your Lordship, are you on same lines with the council? Indeed, Your Lordship, much obliged. Your Lordship, you may refer to para 43, footnoting 51 in the written submission on behalf of respondents. Your Lordship, in the case of D.K. Yadav, the Supreme Court held that the occupation of choice is essentially linked to Article 21, as Article 21 clubs life with liberty, dignity of person, which means livelihood, without which the glorious content of dignity of the person would be reduced to a mere animal existence. Hence, it is most humbly submitted to the Honorable Bench that obstructing an essential practice in a person's occupation with an immediate effect without any reasonable or any absence of concrete fact would amount to violation of Article 19, subclause 1, clause 1, subclause E, subsequently with the Article 21. Before contending for the second prong of the argument, the counsel would like to know if the Honorable Bench has any queries on their end. Much obliged.
She has a
Indeed.
Since you're mentioning that this is only an annual appeal.
Indeed, Your Lordship. Indeed, Your Lordship.
It's an annual appeal. And there's a mention of competitive settlement. Can you please throw some light on that?
Indeed, Your Lordship. Your Lordship, you may refer to para 51 for the same. Your Lordship, by admission of this petition, it would create a vicious cycle of obstructing occupation of farmers in the Pandidi. Your Lordship, as per the concept of competitive federalism, the central government encourages a healthy competition among the states in different arenas. In particular, this one is cultivation of crop and the production of grains. Your Lordship, by encouraging healthy competition among the states through transparent ranking in various sectors, Punjab is a state with population overwhelmingly dependent on agriculture. Your Lordship, if there has been direct obstruction in the essential practice of the occupation of the farmers of Punjab, it would hamper the concept of competitive federalism, as the state of Dehaya start arresting the people of Punjab without directly with an immediate effect, without any concrete grounds on whether in law or whether on facts. It would amount to hampering the occupation overwhelmingly followed in the people of Punjab, which subsequently hamper the concept of competitive federalism, or in other words, healthy competition that encouraged by the central government.
What about cooperative federalism with respect to the health hazards also?
Opposition Lordship, could you repeat the question?
What about cooperative federalism with respect to the accompanying health hazards that follow the practice of stubble burning?
Your Lordship, as far as the present factual matrix of the case is concerned, that could be relevant in the at the case in the hand, that by obstructing the production of either grains or farming in the state of Punjab would hamper the concept of competitive federalism. Indeed, Your Lordship. It is respectfully submitted to the Honorable Bench that as per the factual matrix of the case, which is same referred in the para 5 of the Moot proposition, the agricultural pollution encompasses a large number of contents. Your Lordship, it is subsequently produced that the pollution that has been faced by the state of Dehaya, that has been caused from the side of stubble burning, is annual, and that too is with variation, which has no permanent or lasting impact to an reasonable time. Your Lordship, as per the facts of the case, the pollution contributed specifically by the state of Punjab is nowhere mentioned, and only a false implication was made, and a burden of such ineffective policies of pollution control is only transferred to the state of Punjab. Your Lordship, the farmers use machinery to harvest grain, leaving root-bound stubble behind. There's a lack of market demand for stubble, which could be alternatively utilized for feeding the cattle. But subsequently, the lack of such a demand which attracts the farmer to opt for kharif crop, and that too is within less than 1 month. That too is usually in November, which will leave farmers with no other option but to burn down the stubble considering the time and opt for their next sowing season, that is for rabi crop. Your Lordship, in furtherance, it is presented that the reference to the para 49 in written submission on behalf of respondent, the factual data presented how the smoke pollution rise in the harvest season is temporary with no lasting impact which could be permanently damage the environment. Subsequently, it is presented to the Honorable Bench that the data cited is only for reference, not as a persuasive means or as a concrete ground. Your Lordship, it is most humbly submitted to the Honorable Court that the practice of stubble burning is an essential practice for the farmers of which is a occupation majorly followed in the state of Panjshir, and hence it could be concluded that the cat is already out of the bag. The farmer's stubble burning contribution is indeterminable in the total pollution as per the report. So we are targeting something which is totally insignificant, and the burden of liability is simply imputed on the peoples of Dehaya. Instead of addressing the domestic concern that holds the major contribution in the total report, the imputation of pollution is already passing on to the state of Panjshir. Your Lordship, before contending further on the fourth issue of the case, the Council would like to know if the Honorable Bench has any queries on their end.
You can.
Much obliged. Your Lordship, the concerned facts of the case of the present petition are that by considering the practice of stubble burning, there has been certain news that has been broadcasted in the state of Dehaya, which aimed at spreading awareness against stubble burning and highlighting its prohibited nature under the law. Hence, it is presented that it is humbly submitted to the Honorable Bench that media is being cherished as fourth pillar of the democracy. Its function is to keep the people informed, and in a scenario where people is suffering from serious lung ailments, the media acknowledges the duty with the utmost importance. India, being a democratic state, guarantees the media the right to freedom of speech and expression by the virtue of Article 19, Clause 1, Subclause A, not explicitly, but as per the case of state of Uttar Pradesh versus Raj Narayan. Your Lordship, you may refer to para 55, footnoting 60 for the reference. The Supreme Court held that Article 19, Clause 1, Subclause A not only encompasses the right to acquire information, but disseminates the same, which constitutes that the said right has acquired by the media houses in the current scenario.
Okay, so if there is a piece of information which is very important, but as a media channel, as a news channel, you have to follow the code of conduct.
Indeed, Your Lordship.
So do you think you will violate the program code merely because the news is of utmost importance and it is important in a democracy that people should be aware?
Absolutely not, Lordship, because there has been regulation on the media houses and which disseminates the information. As it is already presented by the Learned Council, the cable television rules and act that regulates the dissemination of news which cannot be slander, which cannot be false, which cannot be against the sovereignty of the India.
Calling a state backward in science and unaware of massive issue of climate change, that according to you is not qualifying as slander.
Your Lordship, it is not. First of all, it is not in derogatory tone because we don't have
Is
intent.
there audio recording also that the tone was heard? We just saw the Moot proposition.
Your Lordship, the factual matrix is silent, so I can't assume the facts. But
You said it's not in that tone.
Your Lordship, you may refer to the last line of the para 8 of the proposition. It is explicitly mentioned that for they chose not to enact such law, in spite of efforts of the highest government representative trying to convince them otherwise. Your Lordship, we persuaded the government to enact as such a law in against stubble burning. But
My question you have not answered. You said the tone was not like that. You said
Indeed,
you
Your
are not
Lordship.
assuming.
Indeed, Your Lordship.
Are you
And
assuming?
no, indeed, Your Lordship, it is presented by the factual metrics of the case as well. That's what I am addressing. Your Lordship,
Where is it mentioned? Please read that.
Your Lordship, it is already presented that the highest government has representative tried to convince the state of Panditi, but by not enacting law, it is inferred because of the conventional mode of system by following their tradition, that is of practice of stubble burning. They are not willing to change. They are not willing to evolve with this time. Without
Answer one question. Was there a disclaimer while this broadcast was done?
Your Lordship, I can't assume the facts of the case as it is.
Do you think a disclaimer is necessary?
Indeed, Your Lordship, a disclaimer is necessary in such a scenario. But
Is anybody asking you to assume facts?
Your Lordship, as far as the factual matrix,
No, did my sister judge tell you to assume facts? You're saying I can't assume. You should be saying that facts are silent. Nobody is telling you to assume facts, counsel.
indeed, Your Lordship, the council apologies if
No,
there has been any violation. And Your Lordship, in furtherance, in the usage of unaware of the massive issue of the climate change, it is presented that the representative of the government of Dehaya has already approached the state of Panditi and persuade them to acknowledge this condition and even asked to frame such a law. Maybe if not to totally ban, but it has to be phased out, which is duly acknowledged by the council on behalf of respondent. Your Lordship, contending further, it is presented that the factual metrics of the present case, the program was aimed at spreading awareness about stubble burning, which is of general public concern. The state of Dehaya adhering to legal provision and not what it has been constituted by the petitioners. As the council has already mentioned the substantiated reason behind both of the comments, whether that is of calling backward in science, that is because of the reason they are not willing to evolve with science and sticking to their traditional method of practicing stubble burning. Furtherance, unaware of the massive issue, even after sending a diplomat to the state of Panditi, they are not willing to change the otherwise. As both of the comments are substantiated by the facts, and Your Lordship, that too is reasonable. Your Lordship, in the conclusion, it is most humbly submitted to the honorable bench that the telecast of factual news program that purely serves the public purpose it serves the pure public purpose, which is same held in the case of Ministry of Information Bureau versus Cricket Association of Bengal in 1995. Supreme Court held that telecast of facts by news media is protected in the provision of the right to freedom and speech of expression. It is most humbly prayed before the Honorable Court that the broadcasted program doesn't violate either of the right of broadcasting code due to the nature of news. Your Lordship, before moving on to prayer, the council would like to close their argument with a quote. Shall the council proceed, Your Lordship? Much obliged. Freedom of speech and expression is the foundation of truly open and democratic society, where ideas can be freely exchanged, challenged, and evolved. Your Lordship, with the due permission of the Lordship, the council would like to proceed ahead to the prayer. Therefore, in the rights of arguments advanced, issue raised, facts stated, and authority cited, it is most humbly prayed and implored before the Honorable Supreme Court of India that it may be graciously pleased to pass and adjudge that the original suit number 35 of 2023, writ petition number 2345 of 2023, writ petition number 3154 of 2023, and writ petition number of 3728 of 2023 are not maintainable and cannot be heard together. The action taken by the state of Dehaya in arresting certain person engaging in the stubble burning is sustainable in law. As per the established principle of environmental law, the state of Pondicherry cannot be held liable for excavating the health issue of the state of Dehaya. Fourthly, the conduct of state news channel in Dehaya doesn't violate any statutory or regulatory code in broadcastment of such program, and for pass any such order or decree as the Supreme Court may deem fit and proper in furtherance of justice, equity, and in good conscience, all of which is respectfully submitted. For this act of kindness, the respondent shall be duty bound forever.
Thank you.
Indeed, it was an honor to argue before this honorable.
Feedback to all of them there. I think that the state of the country is just right. Let's go.
So we've heard both sides and we'll score based on that. But both the sides did very well.
Yeah.
Both side points. Both submissions are very good.